Good afternoon, everyone. We're going to get started. Thank you for coming this afternoon to our lecture that is sponsored by the Fine Arts Department, the Boston College Law School, and the Institute for Liberal Arts. The idea for this lecture came about through some email correspondence between our speaker, Leila Aminadole, and me, and we were talking about the course that I'm teaching this semester with Professor Nancy Netzer. The course is called Loot, Collecting Art in Italy. And in our conversation, Leila was telling me about her recent work on Nazi looted art, and in particular, the Gurlitt case. And I said, wow, it would be fantastic if you could come speak to our class, which she enthusiastically said she would, and she did that this afternoon. And then we thought it would be a great idea to have her give a public lecture on her current work, since it is of great interest to many people across disciplines and also something that we're hearing a lot about in the news. So please let me introduce to you our speaker, Leila Aminadole, who went to Boston College Law School, and prior to that she received her BA at New York University. She is someone who has multiple interests and has figured out a way to combine these interests into a very productive, active, and what I see as an intensely interesting career. And I think this might be of interest to our students who want to think about how they can put together their interests and find a profession. Leila has long been interested in art history, and when she was at BC Law School, she took a class with Professor Pam Berger on medieval art. And when she graduated from BC Law School, she attended a program in Italy that looks into research on art crimes. And when she initially started working in the field of law, she began in intellectual property law, and then shaped her career and moved over to the area of cultural heritage. And that is what she is currently doing at Lombard and Galiebter, where she is off council and is heading up their cultural heritage division. So please join me in welcoming Leila Aminadole and in listening to her lecture on legal issues in art restitution.
Thank you, Stephanie. Would people prefer that I use the microphone or? Okay, just wanted to make sure. Well, thank you for having me here. You've been a wonderful host, and I enjoyed meeting the students earlier this afternoon. It was a wonderful lecture, and I was presented with many great questions. And I'm going to have time at the end for questions. So I encourage you to, write down questions and ask me them at the end of the time. I'd like to answer any questions that you have at that point. Looting has occurred for millennia, dating back to ancient times. From the razing of Persepolis by Alexander the Great, an act that he later regretted, to the looting of Sicily by a Roman governor, cultural plunder has occurred over the centuries. In ancient Rome, art memorialized and even celebrated plunder, as can be seen by the carvings on the Arch of Titus. The carving that you'll see on the right-hand side actually commemorated the booty that was taken from ancient Jerusalem. And even Trajan's Column. The massive monument celebrated Emperor Trajan's 2nd century defeat of the Dacian army and the nation's incorporation into the Roman Empire. In fact, the defeat was so brutal that Dacia was wiped off the map. And the treasures recovered from the defeat were enormous. The metal loot was so great that silver and gold lost part of its value. The treasures eliminated all public taxes and debt and funded 123 days of free gladiatorial events for Roman citizens. This money also funded Roman monuments, such as Trajan's Column. Ironically, this column that was funded by Dacian funds memorializes the destruction and the elimination of the country. And I included a few images from the column. These images depict the destruction of the Dacian army and the looting of the nation. You can see this column in Rome. There are a few wonderful places to learn about this column at some of the Roman museums where you actually can see the column up close and see these depictions of war. More recently, other leaders have laid claim to art and cultural objects. Napoleon attempted to create a new Rome in Paris. Some say that Napoleon was actually the model for Hitler in regards to art theft. He established the first official military division for seizing and shipping art and captured artworks and looted cultural heritage. Called the Commission for Arts and Sciences, it consisted of trained personnel who would follow behind the French army in order to inventory, pack, and ship the objects back to the capital. One of the major art objects looted by Napoleon were the 4 horses of San Marco in Venice, Italy. Ironically, the horses were originally displayed at the Hippodrome of Constantinople, current-day Istanbul, Turkey, and they were looted by the Venetians in 1204 during the Fourth Crusade. They were displayed in Venice for over half a millennia before they were removed by Napoleon and brought to Paris. Eventually, they were returned, but never to Constantinople, but instead, they were returned back to Venice, where you can see them today. However, cultural and heritage looting are not a thing of the past. The past 100 years has laid witness to shocking crimes. There was wide-scale destruction during the Second World War, from the obliteration of Polish sites to the bombing of German cities, the destruction of the oldest Benedictine monastery in the world, located in Italy at Monte Cassino, and the theft of thousands of objects from civilians and museums. For a fascinating look into the pillage of Europe during World War II, I recommend the documentary, The Rape of Europa. In 2001, the Taliban shocked the world by destroying the Bamiyan Buddhas in Afghanistan. The giant 6th century statues had survived centuries of war and attack, but were destroyed by dynamite in 2001 for being idols. The Taliban claimed that their motives were purely religious. Then in 2003, the world was shocked to learn of the raiding of the National Museum in Iraq, where it's believed that 15,000 pieces were lost or destroyed. During the museum raid, display cases were shattered and objects were stolen or senselessly smashed. And these acts are still occurring around the world today in places like Syria, North Africa, and Timbuktu. Governments and leaders justify the appropriation of cultural objects with many reasons. As you can see from the slide, they state that there's a benefit to possessing these objects, a benefit to their people. They claim reasons of moral and intellectual superiority, that they can appreciate the works more than others, and that they deserve to have the works. They also use altruism as an excuse, stating that they care for the works better than other people. And finally, sometimes they claim that the actual owners don't deserve to have the works. In the same way, governments also justify the destruction of objects. They cite to reasons such as religious belief, the weighing of human life versus objects, the casualty of war, their political motivations, as we'll see with the Nazis, Aryanization and destruction of works that are degenerate. They destroy works to create fear, to degrade opposition as a form of propaganda, and as a way to legitimize their new leadership. The theft and looting that occurred under the Nazi regime stands apart in its severity. It's still difficult to comprehend its extent and its brutality. It's estimated that 20% of all art in Europe was looted by the Nazis. This loot doesn't include just art, but includes gold, silver, currency, musical instruments, even personal items. Much of the art that was stolen by the Nazis was destroyed or lost. But on November 3rd, 2013, the world became aware of the Gurlitt collection, also known as the Munich Art Trove. The find was unprecedented, as a family had hidden an extraordinarily valuable art collection for many decades. This collection is still shrouded in mystery. The origin of the majority of the 1,400 works are murky, and the collection is estimated to be worth over $1.3 billion. Cornelius Gurlitt, a German octogenarian, first attracted the attention of police in 2010 after a random cash check during a train journey. The suspicions led to a raid on the apartment in the spring of 2012, where police were confronted with a massive art collection. To understand the magnitude and importance of the discovery, it's necessary to delve into the work's troubled past. During the Nazi regime, Hitler pushed forth his agenda for art. Hitler was a failed artist, and when he came to power, he tried to impose his ideals on art onto the world. He used art as a weapon, a way to degrade people, a way to legitimize the expansion of the Third Reich, and as a propaganda tool. He tried to obliterate so-called degenerate art and replace it with Germanic works. The works deemed degenerate included modern art or unfinished or abstract works that Hitler thought had insulted Germanic feeling. In 1937, the Nazis began ransacking public collections and museums for anything modernist or displayed to be displayed as degenerate, sold abroad, or destroyed. In 1937, the Reich Minister of Propaganda in Nazi Germany issued a decree authorizing a commission to raid museums and select works to be displayed in an exhibition entitled Degenerate Art. 19,500 works were confiscated from museums and gathered for the Degenerate Art exhibit in Munich. The works were displayed without proper curatorial process, and some were even partially covered in pejorative insults. Ironically, it's the most successful modern art exhibition of all time. Afterwards, the exhibition traveled around Germany. I just found this quote to be very disturbing in its reference to this degenerate art, and this was from a pamphlet of the Ministry of Culture and Science that was released around the same time that degenerate art was being collected. And I referenced the success of the 1937 exhibition and the number of people that saw the exhibit. And you can see from this photo that there were lines gathered around the corner to see this exhibition. So after the exhibit traveled around Germany, many of the works were destroyed. At the completion of its route, some objects were auctioned or sold, but thousands were destroyed in bonfires in both Germany and in France. But this is where the story takes an unexpected turn. More than 300 of the exhibited degenerate works were allegedly stolen by art dealer Hildebrand Gerlit, who was Cornelius's father. He reported them destroyed by bombardments, but at least 300 of the 1,400 works in the collection were works that were declared degenerate, while other works in his collection are suspected of being property of Jewish collectors. Hildebrand Gerlit hailed from a culturally prominent family in Germany, and he advanced in the museum world at a very young age. Although he was fired for exhibiting degenerate art, Hildebrand was appointed by the Nazis as a modern art dealer for Hitler's Führer Museum. Hildebrand was a modern art specialist, and he was recruited to raise cash for the Third Reich by selling modern art. He was permitted to buy pieces at fire sale prices from Jewish collectors. After the war, Hildebrand Gerlit was arrested, and he was interviewed by the Allies, and a small portion of his collection was seized. He denied handling confiscated art. He claimed that his collection and all of his documentation was destroyed during the 1945 firebombing of Dresden. The supposedly only surviving 139 works were seized by the Allies and then studied by the Monuments Men. As you may know from the George Clooney film, the Monuments Men were a group of mostly men tasked with preserving and restoring art during the Second World War. They were mostly art professionals who risked their lives by entering war zones to preserve art and restitute stolen objects to their owners. And although some of the celebrities are dashing, I feel like the real-life Monuments Men they also looked pretty nice. So Hildebrand Gerlit convinced them that his works were legally acquired, and thus the objects were returned to him. But he failed to mention that he had some other 1,250 works hidden. For 5 years, Gerlit corresponded with the Monuments Men, and he convinced the Allies that he was innocent. Gerlit himself was actually a quarter Jewish, so his partial Jewish ancestry and his documented history as a champion of modern art deemed him above suspicion. He was actually designated as a victim. He was released, and the works were returned to him. When Hildebrand Gerlit died, he passed along the works to his wife, who also told the same story to authorities, that the works were all gone, that her family didn't have these other 1,250 works. Eventually, when she died, all the works passed down to Cornelius Gerlit. So decades later, in February 2012, based on a court order for tax-related allegations, the works were confiscated by German authorities. At that point, a public prosecutor commissioned a German provenance investigator to examine the collection. So when I use the term provenance, I'm talking about the history of ownership of a work. So there's investigators that are looking at the history, the sales transactions, and any record of its existence and who had owned the works. So the provenance researchers' first task was to determine the identity of the works of art and the identity of the artists. But there were countless unanswered questions about the art trove. As noted by historian Lynn Nicholas, the woman who wrote The Rape of Europa, upon which the documentary is based, she said that there are 4 categories of art in the Gurlitt collection. The first category are works that were legitimately owned by the Gurlitt family. As active members of the art world, the Gurlitts had purchased artwork prior to the rise of the Nazis, prior to the Nazi power. And these works are legitimately owned by Gurlitt. The second category of works are works that were deemed degenerate by the Nazis. And these were works that were removed from German museums and public collections. The third group are works taken from France. It's known that Hildebrand Gurlitt worked in France to liquidate and sell the collections of French dealers. And finally, the fourth group refers to works that Gurlitt had bought from Holocaust victims at fire sale prices. I will be focusing the rest of my talk on 2 of the categories: works seized from German collections that were labeled degenerate, and works that were taken from Holocaust victims. In the case of works bought by victims, there is legal precedent that dictates that works sold under duress are actually stolen. However, it's difficult to determine which works were actually stolen. One of the difficulties in categorizing these works is the lack of information available about the pieces. Each work is unique, and it's a complex task to determine the provenance or ownership history of each one of the objects. So how can the restitution process begin? One of the controversies surrounding this matter relates to the lack of transparency by the German government. German authorities have kept the existence of these works secret for nearly 2 whole years. Bavarian prosecutors have not been very forthcoming in releasing information about the seized objects, and they've cited privacy rights as a reason for not releasing a complete inventory of objects. The government would also not provide information about the object's location during the inventory and research process. Individuals and organizations around the world were outraged, and they've demanded that German officials provide more data as there's need for greater transparency. Groups have requested the German government to provide a full, complete, and detailed inventory of the Gurlitt collection, and to create a nonpartisan commission for the restitution of works. As stated by the U.S. Department's Special Advisor on Holocaust Issues, Stuart Eisenstadt, no one can have a fair restitution claims process without fair access to information. And sadly, as time moves forward, Holocaust victims are passing away. And without their memories, the remaining heirs may be unaware of the family's looted assets and rights to these works. Bavarian officials have defended their lack of transparency, stating that they have not publicized the list out of fear that it would release a surge of false claims from fortune seekers, and that a huge number of claims would arise. The state prosecutors also kept the trove secret for nearly 2 years, so it would not hinder investigations related to tax evasion and embezzlement. Yet pressure from U.S. and Israeli and Jewish groups was so great that within about a week of the discovery, of the announcement of the discovery, the German government disclosed additional information about the collection. The government stated that about 590 of the paintings could have been stolen by the Nazis, and that the government would publicize information about some of the pieces at a website, www.lostart.de, which you can see here, and that this site would be regularly updated. There's now a task force composed of 6 individuals, both German and international experts. The German government has finally recognized that without transparent documentation, a complete clarification as to the origins of these works can hardly be achieved. After all, how can restitution occur without disclosure of information about objects? But even with information about the objects in the treasure trove, heirs of legitimate owners and museums seeking to reclaim works will face major obstacles. Cornelius Gurlitt originally indicated that he would not cooperate. He fought the restitution process and stated that he would not voluntarily return these works. He claimed to be the legitimate heir and that he was unaware of their origins. According to Cornelius Gurlitt, I've never committed a crime, and even if I had, it would have fallen under the statute of limitations. If I were guilty, they would have put me in prison. Although Gurlitt may have not committed a crime himself in the sense that he did not take the works himself, his father did steal these items. And as I said earlier, there's strong legal precedent stating that works sold under duress, works that were not voluntarily sold, are actually stolen. When Gurlitt's father bought these items from Holocaust victims and people fleeing from Nazi Germany, those sales were not legitimate. In the eyes of the law, many of those sales were thefts. However, these transactions took place over 70 years ago. As recognized by Gurlitt, claimants seeking restitution will face the hurdle of the statute of limitations. Statute of limitations set a time period for which lawsuits may be filed. These time periods are established to avoid fraudulent and stale claims that arise after evidence has been lost or facts that have become blurred with the passage of time, the defective memory, the passing of witnesses. So the statute of limitations is supposed to limit when a claim can be brought forward. In Germany, the statute of limitations may favor Gurlitt over the actual owners. The opposite approach of that taken in the United States. In the US, it may be possible for the original owners to toll the statute of limitations, basically to stop the clock from running, by one of two doctrines. Depending on the jurisdiction, one of two rules may apply, either the demand and refusal rule or the discovery rule. The discovery rule tolls the statute of limitations until the owner knew or reasonably should have known the whereabouts of an object. The second tolling statute is the demand and refusal rule, under which the statute of limitations begins at the time that the original owner demanded the return of the object and the current possessor refused to return it. It's also important to note that the demand and refusal rule is tempered by laches, which provides that the original owner cannot unreasonably delay making a demand. In the Gurlitt case, U.S. courts would likely toll the statute of limitations under either one of these regimes to allow claimants to file a lawsuit and begin the restitution process. Under the discovery rule, it would have been impossible for the original owners to know the whereabouts of the works. And under the demand and refusal rule, owners could not have demanded the return of the works because these objects were intentionally concealed. However, the German statute of limitations does not include these tolling exceptions. In Germany, civil statute of limitations are imposed by statute and generally run for 3 years. In some matters, they may be extended to 10 or 30 years, but they may never exceed the 30-year period. U.S. representatives and influential art market players have insisted that German courts disregard the time constraints for cases involving works stolen by the Nazis. 2 months ago, a bill was introduced to the German legislature to eliminate the 30-year limitations period for certain cases involving stolen property, including Nazi-looted art. This legislation would apply retroactively and would prevent someone from acquiring an object in bad faith and then later hiding behind the statute of limitations, even if this person had inherited the work from someone else. This is one of the ways that the Gurlitt case may change the legal landscape in Germany for victims of the Holocaust. Some claimants have also demanded that criminal charges be brought against Gurlitt under the Nuremberg principles. These principles, during the Nuremberg trials against Nazi leaders, classify mass looting in the context of genocide as a crime against humanity. A war crime does not have a statute of limitations, so this would be one way of getting around that 30-year time constriction. Thus, claimants would hope that the German court would charge Gurlitt as an accomplice to war crimes. However, this argument is far-fetched and unlikely to persuade the court because Cornelius Gurlitt cannot be held accountable for a crime that he did not actually commit. As stated by one legal scholar, his father did bad things during the Nazi period, but under the German legal system, you can't punish the son for that. Another way to overcome the restrictive regime of statute of limitations is to bring claims in a jurisdiction with more forgiving time restrictions. Each case involving each individual piece of art is unique. If lawsuits are filed in non-German jurisdictions, those venues may apply limitations rules and tolling exceptions that are more favorable to victims. These include the demand and refusal and discovery rules. However, bringing forth litigation in foreign jurisdictions will depend on the individual facts of each case. For example, some of the works seized by the Allies, which were subsequently returned based upon lies made by Gurlitt, they had been in the U.S. for some period of time. These works could potentially have a connection to a U.S. jurisdiction, allowing claimants to file in this country. Earlier this spring, one claimant, David Torrens, filed a lawsuit in Washington, D.C. and sued Germany. He contended that by failing to disclose the discovery of the art collection for nearly 2 years, the authorities had perpetuated the suffering of victims of the Holocaust. In this case, David Torrens did not file a suit against Gurlitt, but instead filed the suit against the German government. Claimants may also consider negotiating with Gurlitt, as he's cooperated in the past. After selling this painting, The Lion Tamer, for 864,000 euros, he shared the proceeds with the heirs of the original owner. Yet even if Gurlitt agrees to negotiate, claimants must still overcome the formidable task of proving ownership. When Jews and other victims of Nazi atrocities were forced to escape from their homes in fear, the ownership records of their collections were not of the utmost importance. These people were fleeing for their lives. Families were being torn apart, people were being murdered across the continent, and individuals were losing every worldly possession in their names. For this reason, the heirs of these victims will face an uphill battle to recover property. These individuals faced a formidable task, proving ownership without documentation. Without proof of ownership by claimants or evidence of theft, there is no basis for seizure of art from Gurlitt. Ironically, though, hope may be found in Nazi records. Even as Germany was collapsing, the Nazis kept records of their thefts. According to some legal experts, Gurlitt may succeed in asserting ownership over many of the works. The head of the German government agency charged with researching the provenance of art and public collections stated, "The legal situation, as far as I can tell, is that Gurlitt is the rightful owner of a large share of the works in question, even if that is questionable from a moral and ethical point of view." In the case at hand, the legal solution and the moral right may not be the same. Legal determinations must be made according to law and court precedent, although that might not always satisfy our moral and ethical sensibilities. But one of the hopes for Holocaust victims and their heirs is the possibility of new legislation directing appropriate solutions for Nazi-era appropriations. Interest groups are engaging diplomatic discussions in the political process. Discussions have included reference to an international agreement used in the restitution battle, the Washington Principles. As the name suggests, the Washington Principles are principles. They're not law. They're non-binding principles intended to assist in the resolution issues related to Nazi loot. Although admirable in their purpose, the articles are vague. The convention calls for a just and fair solution and recognizes that fairness and justice of a solution will vary according to the facts and circumstances surrounding a specific case. Along with 44 other nations, Germany was a signatory to the Washington Principles. However, claims are being made that Germany is not abiding by the principles. Germany has not adopted a formal national approach to restitution, and the German system places the burden of proof on claimants, even in cases related to Nazi loot. Under the 5th article of the Washington Principles, every effort should be made to publicize art that's found to have been confiscated by the Nazis. Germany does have an office solely devoted to restitution claims, the BADV, but the office has not been responsive or forthcoming with information. Germany failed to publish a full list of the works until a court ordered it to do so. Also, restitution claims are difficult to enforce, in this case, under the Washington Principles, because the principles apply only to state institutions and not to individuals, like Cornelius Gurlitt. Courts and law enforcement officials may determine that Gurlitt is the actual owner of the treasure trove, even though this is questionable morally. Not only has the statute of limitations expired and owners are unable to prove their ownership claims, but Gurlitt has had possession of these objects for decades. Under the German doctrine of prescription, title to someone else's property can be acquired without compensation by holding the property for a set time that conflicts with the true owner's rights. In Germany, this time period is 10 years. This is similar to the concept of adverse possession in U.S. law. Whereas that in the U.S., where adverse possession only applies to real property, real estate. In the U.S., prescription also applies to personal property, including art in Germany. As the legal process is so complex, uncertain, and time-consuming, and sadly, during the process, any surviving Holocaust victims may pass away. The best option may be for Holocaust heirs to work through this process by negotiating with Cornelius Gurlitt. As I mentioned earlier, he did return works, or he did share in the sales proceeds for the sale of the Lion Tamer. Finally, actually I'm going to not go there yet. Finally, if all else fails, hope rests with the German government and diplomatic posturing. Returning the works to Gurlitt is shocking to the collective conscience. For this reason, international politics may play a role in the search for an equitable solution. The German government may find it necessary to intervene in order to avoid a morally reprehensible outcome. U.S., Jewish, and Israeli officials are calling on Germany to improve its restitution policies to find a proper resolution to these issues. Since the announcement of the Art Trove's existence, there have been many developments. Another 238 works were recently discovered in Austria at another one of Gurlitt's homes. In February, he filed a lawsuit against Germany, claiming that German authorities used false charges of tax evasion to illegally seize the property, and that his property should be returned to him immediately. Gurlitt asserts that there's no legal basis for the German government to possess the works. Interestingly, on the same day that Gurlitt filed his claim, new legislation was introduced for Nazi-era thefts. This is the aforementioned legislation that would eliminate the 30-year statute of limitations. And it was also determined that 310 of the works in the collection actually legitimately are Gurlitt's. These were purchased by his father before the Nazis came into power. Then last week, a major development, that's Cornelius Gurlitt, by the way. I probably should have shown that earlier. Last week, a major development was announced. Gurlitt and the German government reached an agreement. Gurlitt would allow provenance researchers to investigate the works once they are released from police custody to him. An appointed task force would research the provenance of works suspected of being confiscated by the Nazis. The group of researchers would include one appointed by Gurlitt, and the investigation would be completed within the year. Artwork suspected of being Nazi loot will remain in secure custody, and they will be posted on the Lost Art database. This process is being funded completely by the German federal government and the state of Bavaria, where Munich is located. As part of the agreement, works for which the task force have not completed provenance research within the year will be returned to Gurlitt. But researchers will have continued access for their examination. Gurlitt also agreed to recognize the Washington Principles by means of restitution for persons claiming ownership of the works. And the works that are definitively determined not to have been confiscated by the Nazis will be returned to Gurlitt and be deleted from the Lost Art website. This agreement will take effect when the works are released to Gurlitt. Fortunately for claimants, the agreement bypasses the 30-year statute of limitations. This sounds all great. However, there are problems with this agreement. It's been argued that the one-year research deadline is not sufficient, and that it's unlikely that the true owners will file a claim without knowing the identity of the works in the collection. Even at this point, fewer than 600 of the works have been listed on the Lost Art website. This solution also leaves too much in the hands of the selected provenance investigators. And most troubling is that the burden of proof is still on the claimants to prove ownership. As mentioned earlier, proving ownership is a monumental task. The difficulty in filing a claim is reflected in the low number of claims already filed. Gurlitt's spokesperson said that he does not expect more than 5% of the works to be claimed by those in search of works stolen or extorted by the Nazis, and that the bulk of the collection was legally acquired. In fact, so far, only 6 paintings have been claimed. One of those works now is also being disputed because it's being claimed by 2 separate parties. It's this work. One of the first works that Gurlitt agreed to return was Seated Woman by Matisse, which was set to be restituted by the Rosenberg family. Paul Rosenberg was a prominent art dealer in Paris. He was renowned for representing Picasso, Braque, and Matisse. Although negotiations had taken place and Gurlitt actually consented to return the work, the deal quickly came to a halt earlier this month when a second person came forward to claim the painting. The restitution process has been indefinitely delayed as authorities are required to investigate this new claim. However, besides the stolen works belonging to Holocaust victims and their heirs, there are hundreds of works, estimated to be around 380, that were stolen from museums that found their way into the Gurlitt collection. Sadly, it's likely that the works will continue to be hidden from public view, as the Gurlitt family will be able to keep all of these pieces that were taken from museums and deemed to be degenerate. The law on the confiscation of products of degenerate art, passed on May 31st, 1938, decreed that the Third Reich could appropriate art from public museums in Germany without compensation. The confiscation law allows the Nazis to seize degenerate art that Hitler viewed as un-German or Jewish in nature. Shockingly, this law is still valid today. Unlike anti-Semitic laws that were revoked after the fall of the Third Reich, the 1938 law regarding degenerate art still exists. Under German law, there's no obligation to return these seized works to museums unless they were loaned by private individuals or had foreign owners. The German government and professionals in the art world are hesitant to repeal the law for fear that it would open a Pandora's box and it would unravel an intricate web of agreements involving Nazi loot. The law, therefore, makes it unlikely that any of the museums will be able to reclaim their works. Although the 1938 confiscation law is reprehensible, it's possible that nothing will be done about it. There have been discussions regarding the elimination of the law, but nothing has yet been formally proposed. When a government expropriates property from its own citizens within its own territories, it is deemed an act of state and will not be questioned by U.S. courts. However, the U.S. may be willing to intervene in this case of government taking because the U.S. State Department has indicated to the courts that it's not important to defer to the act of state doctrine for laws of the Nazi regime. It's not important to our foreign relations to defer to Nazi laws, and for this reason, the state expropriation of museum objects may be viewed as theft by Nazis. Furthermore, the U.S. has never formally recognized the Third Reich as a foreign sovereign. However, the courts may not have an opportunity to examine this question because nothing has been filed in the United States. The victim in this case is the German public, and to the best of my knowledge, no restitution claims have been filed by German museums or public institutions. The only way for this question to be raised in the U.S. would be if one of these degenerate works was sold to a U.S. citizen. In that case, a German museum may file a claim in U.S. courts to declare the works as stolen and begin claims for its return. However, this is a novel situation without precedent. It would be very interesting to see how the court would decide this issue. There are so many unanswered questions relating to the Gurlitt collection. Will this discovery prompt a change in German or international law? Will the statute of limitations be modified for cases involving Nazi loot? Will this case change the legal landscape for all future Nazi looted art disputes? And should the objects without heirs be taken from Gurlitt? If so, where should they go? And what will happen to all these works once Cornelius Gurlitt passes away? Should just mention that he hasn't had children, he's not married, he has some relatives, but they're all more the distant cousins. So it's unknown what will happen. And I just saw this on the news on 60 Minutes last week, that he did make a provision for the works in his will, but it's unknown to the public what this provision is. So there are many unanswered questions, but one thing that we know is that we will be examining legal and moral questions for years, if not decades. Are there any questions? Are there any questions?
Thank you so much for presenting and going to our class today. Actually, that was really great. I just had a question about the lion tamer painting that he split the profits of the sale with the family who had owned it before. How did that come about that he was connected with that family or they knew who owned it previously? How did that really come to be?
I don't know the details of that case. So what I had mentioned earlier in your class is that the German government knows that Cornelius Gerlet had sold a few of the items. It doesn't seem that he sold many. He wasn't living an extravagant lifestyle, but he just sold enough to keep himself going and to pay his bills. So it seems that there weren't that many sold. That was one that I'm not sure how they were able to trace it. And I think the settlement agreement that he reached with the heirs, I think it was confidential. So I don't know what the split was on the proceeds. I don't know if there's anyone else in this room that would know more details about it. But I hadn't read any of the details of how that really came about. I think the settlement was just kept very quiet. Currently, as I mentioned, there was the Matisse negotiation that was going on, and the terms of that agreement have also been kept confidential.
Thank you very much for that talk. It was pretty interesting. You mentioned earlier that there's very much established precedent that art sold under duress is considered stolen art. Is that a precedent established in Germany? There's a different type of jurisdiction in the U.S. mainly. It's a common law jurisdiction where precedent serves as kind of as law in itself. But in Germany, under a civil law jurisdiction, I'm not sure if precedent has as much sway.
So, yeah, I'm an American attorney. My expertise is in the U.S. And yes, under our common law tradition in the U.S., we have recognized these forced sales, these duress sales, as theft. In Germany, one of the complaints about the German system is that they haven't had a very clear restitution process. So that is one of the complaints about the process in Germany. So I'm mostly speaking toward the U.S. process in our case law. And of course, if there's anyone in here that would have any additional information, I welcome you also to chime in.
Did Gerlet pay taxes in Germany?
No, and that's how they discovered him. He was living under the radar. He wasn't working. He wasn't paying taxes. He was a ghost. People referred to him as a ghost, where he paid for his apartment in cash, and they started investigating him because they were wondering where this cash was coming from, because he wasn't a working individual. He wasn't part of the workforce. He was very much a loner. He didn't have family. He didn't have friends. So he just wasn't paying the taxes, which he claims was the excuse for seizing the collection. But that's really how he came under the radar of German officials.
It sounds like he's getting off scot-free.
It is a really difficult situation, and I think that's why I said, the law and our morals are really in conflict in this case, because we want to see him pay, but under these time limitations, he's saying you can't bring cases against me, all these technical rulings, that's what he's using. He's using these technical arguments. But I think that the press has made his life so miserable in the past few months that he did change his story. Originally, he said, they're mine, I'm not returning anything. And the pressure from the press was so heavy that he did just announce last week that he is negotiating and he'll return objects. As I said, that agreement really isn't sufficient. Even it's going to be hard for those heirs to get their works back, because it's going to be difficult to prove ownership. So really, it seems like he's just doing this as a token gesture. You're going to have a year. send me your claims, but he knows himself they're going to have a really difficult time proving ownership. So he does seem to be getting out of a lot of trouble.
Is there any speculation as to what his will?
No. His lawyers spoke on 60 Minutes a week ago, last Sunday's 60 Minutes, and the interviewer had asked, do you know what's going to happen when he passes away? And they said he doesn't have any heirs. We don't know. He did put something in his will, but they just don't know what it is. And I think that actually answers that. I think is one of the most interesting questions. If he decided to leave the works to his cousins or second cousins, what will those individuals do? Or if he actually decides to leave the works to the German public, or museums, will museums actually accept those types of works? Because there's a problem with the ownership and with the title, and museums might not want to accept an object, knowing that later on down the line they're going to have to spend money defending themselves in a litigation because there's problem with title. So I actually think that the more interesting questions might be raised when he passes away, to see what's going to be done with those hundreds of works once they're out there.
Does Germany have an inheritance tax that he's liable for from his father for all of this work?
Oh, that's something I don't know. I'm not a tax lawyer, and that I'm not sure about. I don't know if there are any tax attorneys in this room. I don't know that.
$1 billion?
Yeah, 1.3. They're saying 1.3 billion, and that was the November estimate. And they found additional works in Austria. So yeah, I'm sure it's above 1.3 billion now. Yeah, I don't really know about the inheritance. And I think there would be a lot of really interesting tax questions also, like the evaluation. Would they be evaluated at their 1960s rate when he actually got them? Or
just the fact that he avoided presenting it, that itself is a reason for cutting him away.
Yeah. I'm not a tax lawyer. I wish I knew more about that. I'm sorry.
I was shocked to hear that the Nazi law giving the government the right to confiscate works from museums on the ground that they're degenerate has never been repealed. But to your knowledge, it has never been implemented or used against the museums since the fall of the Third Reich.
Yeah.
Right?
Yeah, and well, I think that's why it hasn't been repealed. This case hasn't really come up. I think they thought these works were destroyed. Everyone's thought was the works were taken away and then burned in bonfires. And what Hildebrand Gerlit did was that he lied to the German officials. He didn't tell them that he kept these works. So he kept them hidden. So that law being in place, and with museums, they probably didn't think it was an issue that was going to rear its head again. And there were some interviews.
That Angela Merkel could say, I don't like this piece in this museum, and therefore I will.
Well, maybe this.
I will have it destroyed, burned, etc.
Yeah, maybe they thought it was never going to come up again, but now I think they realize that this law should be repealed. And there were some interviews with museum officials from Germany who said, we just don't want to touch that law because there's this balance of all these different agreements. Once they repeal that and we start looking at collections, there are going to be a lot of claims, and it's more of a hassle, it's more of a headache than what it's worth. And I mean, that's the impression I got from reading a few different interviews from the museum community. But nothing has been done. And even though there have been laws or bills that have been introduced about statute of limitations and the restitution process, none of them relate to this degenerate art law.
Are there any patrimony laws, and I don't know anything about German law, and are there any patrimony laws so that if some of the works were to be distributed to later relatives? I remember on 60 Minutes, one of his cousins lives in Barcelona.
Yeah.
Would there be any issues about getting this work out of Germany?
With most patrimony laws, usually the work's like 100 years or older. I think they'd be too modern.
I think Italy's 50.
Oh, is it really 50? Yeah. The Italians are so strong with their patrimony. I don't know. I know Germany has patrimony laws, but I know that they're not as strong as Italy's, and I don't know what the time period would be like. I'm surprised Italy's is 50. I know France is 100.
Works of art.
Yeah.
Or Germany, like presumably a German origin.
Yeah, and the thing is that these are mostly German origin of really well-known German artists. And it's interesting because the question earlier today was, why wouldn't people have these records or something along those lines? And at the time, these weren't really valuable works. These were contemporary works, and these were unknown artists. Yeah, people didn't really value these. At the time, they were not very expensive, and since then, they've raised in value. So, yeah, I'm not sure how it would work with the patrimony laws, but because I don't know the details of the dates.
Coming out of Germany, but a lot of these works of art are works on paper. They're not unique, some of them.
Yeah.
They're not significant, so I would be surprised.
Yeah, and that's the thing. The majority of the works are actually like sketchings and drawings. There are a few very expensive works, like there was the Matisse, there's some Picassos. I know there are a couple of Chagalls, but a lot of them are just sketches. And maybe the German government wouldn't want to, require like an export passport for something that was so minor. Any other questions?
It's less of a question and more of a comment. I think that one of the things to look at or to talk about is, when you hear these big numbers, it's $1.3 billion. You think of this guy living like the life of luxury, and he doesn't. He lives like a hermit. He lives in a little studio with like 1,400 paintings stuffed into it.
Yeah, and I think it's really interesting to know that his apartment is a 900 square foot, very simple apartment, and he had 1,400 works stored in the apartment. Now, there was some damage done to the art because they weren't stored properly. But that is one of the reasons that they believe that the works were not many works were sold, that there were really only a few works sold because they were being sold to, just so that he can pay his expenses. So they know he wasn't selling millions of dollars worth of art and living an extravagant lifestyle. He was just selling enough to, pay his way. And the other thing about his relationship with the art is that he was obsessed with the art. He made a statement, the same year that the art was seized from him was the year that his sister had died, and she was the only relative he was close with. And he made a statement after the works were seized that that was the most difficult thing he had to ever deal with, and that he was more affected by that than by the death of his sister. So this man was really obsessed with these works, and kind of in a twisted type of way, that he just had them stored in his apartment for his own viewing. Yeah.
This all is a perfect description of a psychotic hoarder.
Yeah.
And people hoard cats, and people hoard newspapers and magazines, and Gurlitt is hoarding pictures. The mess of the interior of the apartment, the poor condition that he allows them to deteriorate to. This is exactly what it is. And in our country now, it's on the list of psychotic diseases that can be treated by psychiatrists and they get paid for it now. So this is a psychological problem as well as an art problem.
Yeah, I mean, I just can't imagine his frame of mind for decades to just be living in this apartment, doing nothing with his life. I mean, I don't know what he's doing with his personal time, but he didn't have friends, he didn't have family, he didn't work, he was just staying in his apartment looking at this art. So it reminds me a bit of the story of the man that stole the Mona Lisa, who had kept that painting under his bed and would look at it every day when he came home, and he became obsessed with the work. So yeah, in a very similar way, this Cornelius Gurlitt was just obsessed with the works.
Well, please join me in thanking Layla for teaching us.